Imagine a referee in a football game who's dating the quarterback's sister. Even if he tries to be fair, wouldn't that raise questions? Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. Judicial bias is one of the most serious threats to the integrity of our court system. Yet, it's often invisible to those outside the legal profession. So today, let's shed some light on that subject. How big is the problem of judicial bias? Well, depending on who you listen to, judicial bias is rare but serious. The vast majority of judges, I think, strive to be fair and impartial, and the legal system gives them broad discretion. But it also gives them court rules that make them the arbiter of whether they can be fair. Usually, honest judges do their best to be fair. However, surveys show that public perception of bias is higher than actual incidents. For example, a 2023 survey by the National Center for State Courts found that more than 40% of Americans believe judges are influenced by politics or campaign donations. I suspect that view is probably higher today. Documented instances of actual bias or conflict of interest are fewer, but can be impactful. I'll tell you a little bit about a case called Capertton versus A.T. Massie Coal Company, a 2009 case from the Supreme Court here in just a little bit. In that case, a judge failed to recuse himself despite major campaign contributions from a party to the case. Now, my experience with judges where potential conflicts of interest developed is much better. Missouri's court system maintains strict control of its judges, and it gets involved when they go off course. But usually, they're very good about maintaining impartiality. I've had judges rule against me, right? Because they thought my objection was invalid or because they thought my client was lying or whatever. I've had them rule against me, but I never thought that it was because they were biased or they were bought and paid for it or anything like that. The fact is, most judges just try to do a good job of being a neutral arbiter. So in 2014, I was preparing to try a nursing home case. And we had a brand new judge, what we call a baby judge, who hadn't tried many cases up to that point. In fact, he hadn't even been to the Judicial College yet, which is something that the court system puts on for new judges. We fought out the voir dire and argued over initial jury instructions and had finished picking the jury in that case. We were just about to go to opening statements when the judge did this, said, "Come on up." So he called us up and he first looked at me and he said, "Mr. DeWitt, until I saw and heard your client speak, I didn't recognize her. But I'm pretty sure that before Judge Beadham and I became judges, we represented her family on a couple of matters." And of course, the entire family in a wrongful death case, which is what we had, would have been beneficiaries of any judgment that came in. So he actually took it further than he needed to. He hadn't represented her personally, he had represented some of her family members. Then he turned to the defense and he said, "And I'm absolutely sure, now that I think back about it, we did some work for the Sisters of St. Mary." Editorial note: my boss, who was a Supreme Court judge at one time, referred to them as the Sisters of Sadomasochism because of a bad experience he had in physical therapy. And I've always thought that was a pretty interesting name for them. But at any rate, they owned the nursing home. And he told them, "So I've worked for both parties in this case. Now, I have no preference for either party, and I think I can be fair. But given this, I wanted to offer you a chance to seek recusal if you want it." So I went back and talked to my client, and it turned out that both of us wanted the judge off the case. My client wanted him off the case because she wasn't sure she trusted him, and I wanted him off the bench because he hadn't had a lot of time on the bench. The defense was equally adamant that they wanted him gone because they didn't want somebody who'd been representing one of the party's plaintiffs. So he recused, problem solved, Neither party had any way to know that the judge should recuse before he disclosed that information. My client didn't recognize him, and the people from the nursing home didn't recognize him. So the judge did absolutely the right thing. He disclosed the information, and then when we asked him to recuse, he did. So, when does judicial bias most often occur? Judicial bias can take several forms. It most often arises in the following contexts. First of all, personal or financial interests. A judge has a financial stake in a company or a personal relationship affecting the outcome. If you file a case in federal court and you are a corporate entity, you have to list the corporate interests and any corporations that hold that corporation. And if it is a closely held corporation, I believe sometimes you have to list the names of the people who are holding that corporation. And you do that so that the judge can make a determination as to whether he should recuse or not. Another one, campaign contributions, especially in elected judicial systems, like even some cases like Missouri has appointed judges, but some of the lower level judges at the circuit court level are elected by the public at large, unless I think it's Cole County, Greene County, um, Jackson County, and St. Louis City and St. Louis County. Those judges are appointed by the governor. Everybody else out in the county, in the downstate, they are elected by the public. So when you run for a judicial office, you have to raise money for campaign signs and advertisements and all that. And your donors, they can later appear before you. And so that can create the appearance of bias. Now, one of the things that's interesting is that lawyers give to judicial campaigns all the time. In fact, I know a firm where if Judge A is running against Mr. B for a judicial election, and they have $1,000 that they want to spend on that election, they give $500 to both candidates. They're hedging their bets because if this guy unseats the judge, they want to make sure that they are not on the wrong side of that judge. Even though there should not be any wrong side of a judge, you play it safe if you try cases in a courtroom. Prejudgment or favoritism. A judge openly favors one side or makes public comments that show they have their mind made up before the hearing. One of those bring that guilty so and so in here and we'll have a fair trial is not the kind of judge you want in most cases. Implicit bias. Unconscious biases involving race, gender, and socioeconomic status. I think this is probably the most common form of bias, inasmuch as the judge, by virtue of it being implicit, doesn't understand that they are biased. But if you look at the disparities in treatment between people of color and white people in matters like criminal justice, you can tell that unconscious bias, implicit bias does exist, and that we need to work on eliminating it to the extent that we can. And then prior knowledge or involvement. The judge previously worked on the case in another role, or, as my judge did, previously worked for the parties in another role. So your client has a judge who isn't playing fair. What does the lawyer do? Well, lawyers face a tricky balance, raising bias without alienating the judge. Common strategies include filing a motion to recuse or disqualify. If there's a reasonable basis, lawyers can file a motion requesting that the judge step down. This is more common in civil or high profile criminal cases than it is in your run of the mill case. But there's an old aphorism that says if you shoot at the king, you had better hit him, because no judge likes to have their impartiality called out in front of a large number of witnesses. They don't want to be called out for bias. And if you do that, you're probably going to put a splinter in the finger of that judge and it will come back to haunt you. So you have to be careful about that. In fact, some people have suggested that because the judge in the Karen Reed case they sought her recusal and she refused to recuse, that it's coming back to haunt the defense in this case now. I can't say whether or not that's the case, but I can say that In my estimation, the judge does seem to be ruling for the prosecution a lot more often than she is for the defense on equally valid objections. Even if recusal is denied, you have to create a record, and it's critical to document any questionable behavior for appeal. In some cases, the judge won't let the lawyer make the record. You go to the judge and you say, "Judge, I'd like to make a record here." And if the judge says, "No, you're not going to make a record," well, then you make an offer of proof. "Judge, I would like to make an offer of proof for the record." And if the judge doesn't let you do that, then you draft a memorandum, and at the end of the trial, you file that memorandum documenting it along with your motion for a new trial so that it gets into the record and the Court of Appeals or the Supreme Court has something to base their ruling on when you say this judge should have recused or this judge was biased. So you have to make either an objection, make a record, make an offer of proof. You respect the ruling of the court, but you push back as far as you can. Lawyers have to be tactful. Direct accusations of bias can backfire. Instead, most lawyers will say, "Well, Judge, you have the appearance of bias," meaning that a reasonable person who looked at this by virtue of the fact that you've ruled 80% of the time for the prosecution here, well, they might think that you're biased. So, we ought to really put that to bed so that we don't have that problem to worry with. Sometimes you use statistics and behavior. "Judge, every time Honk over there says objection, you say sustain before you even hear the legal basis of the objection. We can't have a clear record if you do that." Again, you call out the behavior, not the judge personally. You make it seem like you want to protect the record, something you can't be held in contempt for, at least not legally. You have to know the law. Federal and state rules vary, but all judges are bound by the canons of judicial ethics, especially the principle that judges must avoid even the appearance of impropriety. And then, if bias affects the outcome, you appeal after the judgment. The remedy is usually appeal, but it can be very hard to show prejudice without procedural unfairness. And that's why it's so important to document your belief and the behaviors that you associate with bias, and if you can, get them into the record. I would also add that after the trial, where a judge has been over the top, unfair, a complaint to the judiciary or its disciplinary committee is probably in order. Now, I mentioned Capertton versus A.T. Massie Coal Company, which is 556 U.S. 868, a 2009 case from the Supreme Court. After a West Virginia jury found respondents, a coal company and its affiliates, Massie, liable for fraudulent misrepresentation, concealment, and tortious interference with existing contractual relations, and awarded Caperton $50 million in damages, West Virginia held its 2004 judicial elections. Knowing that the state Supreme Court of Appeals would consider the appeal, Don Blankenship, Massey's chairman and principal officer, supported Brent Benjamin rather than the incumbent justice seeking re-election. His company spent $3 million in contributions, and that exceeded the total amount spent by all other Benjamin supporters and by Benjamin's own committee. Benjamin won by fewer than 50,000 votes. Before Massey filed its appeal, Caperton moved to disqualify now Justice Benjamin under the Due Process Clause and the state's Code of Judicial Conduct based on the conflict caused by Blankenship's campaign involvement. Justice Benjamin denied the motion, indicating that he found nothing showing bias for or against any litigant. The court then reversed the $50 million verdict. During the rehearing process, Justice Benjamin refused twice more to recuse himself, and the court once again reversed the jury verdict. 4 months later, Justice Benjamin filed a concurring opinion defending the court's opinion and his recusal decision. When it got to the Supreme Court held that due process required the judge to recuse. The Due Process Clause incorporated the common law rule requiring recusal when a judge has a direct, personal, substantial, pecuniary interest in a case. They cited Toomey versus Ohio. The court also identified additional instances where, as an objective matter, they required recusal with the probability of actual bias on the part of the judge or decision maker being too high to be constitutionally tolerable, and they cited to Withrow versus Larkin for that. The court cited as an example a case where an Alabama Supreme Court justice cast the deciding vote upholding a punitive damages award while he was the lead plaintiff in a nearly identical suit pending in Alabama's lower courts. That's Aetna Life Insurance versus Lavoie. The proper constitutional inquiry wasn't whether, in fact, the justice was influenced, but whether sitting on that case would offer a possible temptation to the average judge to lead him not to hold the balance nice, clear, and true. While the degree or kind of interest sufficient to disqualify a judge can't be defined with precision, the test had an objective component. The court said that in Mayberry versus Pennsylvania, 400 U.S. 455, it rested on the relationship between the judge and the defendant. The court noted that the objective inquiry was not whether the judge was actually biased, but whether the average judge in his position is likely to be neutral or there is an unconstitutional potential for bias. So, what Capertton did, and what these cases cited by Capertton did, is they set the floor for recusal where there is a potential for bias based on objective criteria. Cases since this 2009 SCOTUS opinion have centered around gathering enough objective evidence of bias to reach that Caperton standard. That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.